I'm Vijaya in conversation with the immigration attorneys of the NPZ Law Group, serving immigrants and employers throughout the US, Canada, and around the world. David Knockman, founder and managing attorney at NPZ Law, joins me once again. David, do I need to have an employer to pursue the green card?
So that's a great question, Vijay, and also one that we get frequently in our office, and especially one in in an economic environment that may be in turmoil, because folks are really concerned about whether or not they're going to be able to continue, with an employer through the process of sponsorship. So, but in answer to your question, I'm going to give you the lawyer's answer, and the answer is yes and no. So the answer is that there are self-sponsoring categories. There's one specifically in the EB1 classification, that's for individuals with extraordinary ability. And then there's one in the EB2 classification that's called the national interest waiver. And those classifications are self-sponsoring classifications. And we'll talk about those in a second. But the answer is that generally speaking, otherwise you would need to have an employer who would sponsor you, and those are for the other employment-based opportunities for the green card,
like the H1 and others, right?
Well, those are on the non-immigrant side. I think you had asked me about green card options,
yes.
So on the green card side, the two self-sponsoring classifications that come to mind are first the EB11, individual with extraordinary ability. We don't like to use the word alien anymore. The individual with extraordinary ability. Well, who are these people? Well, these people are folks who have publications, they have citations, they have very high levels of salary. They also have recognition in their field. Oftentimes they've worked for institutions that are distinguished in their field. And this classification is a very high level, a high legal standard to meet. And it's really not for the faint of heart. It's really, and it's something that we in our office, the lawyers in our office, when we do an analysis of a resume, we look at it and we refer to it often as a smell test. Because we know that if we're being given a resume of an individual with extraordinary ability, we know it when we see it. And we have a pretty good sense. I mean, there are some, of course, that are marginal, but for the most part, we know if an individual is an individual with extraordinary ability.
Yeah.
And one of the interesting things is that there's a legal criteria that's applied to the CB11 classification for extraordinary ability. It's called Kazarian. It's the Kazarian legal standard. So even if you meet certain objective criteria, there's still a subjective determination that's made, and so it leaves a lot of room for discretion by the officers. And then in the EB2 classification, the national interest waiver, which is not of so much interest to the Indian community because unfortunately it's quite backlogged. The EB1 is not as backlogged. The EB1 is back maybe about a year or two, but the EB2 is back a very significant period of time. So the EB2 is not of great interest, but it is a way to lock in a priority date, and it's super important for individuals who, let's say, are H-1B and need to get extensions of that H-1B beyond their 6 years. So they would maybe lock in a national interest waiver classification in EB2, and then work on their resume over time to improve it to try to get to an EB1. And we often get calls about that, and we work very closely with our clients to try to help them to improve their resumes. But just going to the national interest waiver classification, that's for an individual with exceptional ability who's going to be serving in the nation's interest, and that's there's a standard called DANSFAR. It's the name of the case that applies in the national interest waiver classification, and that deals with the individual's ability to persist in their field, and that means that they're going to continue to be involved in their field of expertise. So these are two of the self-sponsoring classifications. So the answer, going back to your question, is no in terms of the EB11, and in terms of the EB2 national interest waiver, you do not need to have an employer to sponsor you. Now, however, and sort of as an aside, if you do have if you do have an employer who's willing to sponsor you, that could make the case stronger. So that's part of our analysis, is that we could go down that road, even though it's a self-sponsoring classification, and we could go in the let's say down that road with a sponsor, and that might make the case for the clients much stronger.
So, I mean, just a thought, can you do this parallelly though?
Yes, absolutely. In fact, I received a call yesterday from a client who wants to do an EB-1 extraordinary ability case simultaneously with a national interest waiver case, and he wants to lock in and take a chance on seeing whether or not the EB-1 is going to go through. So yeah, absolutely. And, then it just becomes a question of, whether or not they can afford the fees that are associated with that. And what our firm does, we're very mindful of the fact that there is a fee associated with each particular classification, but there is a lot of work that is redundant. And so what we do is we don't charge any extra for the work that we've already done. Yeah. And so what we do is we give a discount for the second classification if the individual wants to try both at the same time.
Oh, nice. That's nice of you, David, to do that.
Yeah, the federal government's not going to do that, right? They charge full freight on both cases, unfortunately.
That's right. Yeah. Well, thank you for putting that excellent explanation out and very succinctly really covering it all.